Please rise. 34th District Court is back in session. Your Honor, Tina Brooks Green presiding.
Have a seat. All right, Ms. Shackelford.
Judge, I did find a case with respect to constructive possession, but I think given the evidence that came in at the preliminary exam in good faith, I will just withdraw that count.
Okay, so we're going to dismiss count 4 against Mr. Moore. Okay, go ahead with your, I think I interrupted you. Maybe.
Your Honor, I think I'm done making my arguments.
All right, Ms. Joseph, anything else?
I guess, Judge, I would just respond to the statements about individuals who may or may not know Mr. Moore. I would just suggest that there's been no testimony or witness statements or likely investigation about whether Mr. Moore knew other individuals that had lived in that home previously with Ms. Covington. There was testimony those lights had been there for a long time, and there's been no other evidence that Mr. Moore didn't know someone else who may have touched them. And the DNA evidence the prosecution raised, it's an investigative hit. It is not saying his DNA was found on the lights. It's a complete overstatement of the evidence that's been presented. It's just saying we need to do more tests. And I would suggest to the court there's no other hits of investigation or association of Mr. Moore's DNA on anything else in that home. If he was truly involved in the way the prosecution is trying to argue he was involved, there would be more. There would be more DNA evidence or hits or something other than that. And I would suggest our argument about Mr. Moore not knowing the witnesses who testifies, it diminishes their credibility, I think. They didn't know him at the time. And it also shows that the prosecution's theory of this case, it doesn't make sense. Why would someone go into a home where they don't know the person, tie that person up, and then shoot them? If someone's going to rob a home for marijuana, of all things, marijuana in 2017, robbing a home for marijuana, first of all, is, I think, a pretty weak theory. But okay, even if they're going to rob a home for marijuana when there's dispensaries and groweries and every street corner.
Are you saying that Mr. Edwards' testimony that his home had been robbed prior to that is not to be believable?
Well, Mr. Edwards' testimony is not admissible against my client.
No.
So,
I'm asking that.
Or I'm sorry,
just,
Mr. Evans.
No, I'm saying Mr. Edwards, the neighbor, had said that his home had been broken into and THC related things had been stolen before. You're making the argument. I'm not making the argument. You're making the argument that in 2017, nobody's going to break in and steal marijuana. Well, I'm asking you, are you asking me not to believe the testimony of the neighbor that his home, in fact, indeed was broken into a couple months before this incident in regards to THC related items?
Judge, I'm asking you to take that testimony in its fullness. And that testimony was that someone may have stolen his wax, butter, different type than just loose marijuana.
And I'm only raising it with you because I sit here all day and people have, even with the legalization, there's this, that the dispensaries are more expensive, that it's cheaper to buy from the guy on the corner. I mean, so yes, there's still issues of theft or whatever going on. And so I understand.
I understand, Judge. I would just point out to the court that there was, I believe, testimony that it was Mr. Edwards' understanding it was a friend or someone that he knew, whereas he doesn't know my client. So I would distinguish that from this. And I would just point out that it doesn't make sense for someone who doesn't know the alleged victim to tie her up and then shoot her. If you're involved in a robbery, why tie the person up? That's just the point of that. But thank you.
Anything else, Mr. Goldstein?
Very briefly, Your Honor, I'm going to stand on my argument earlier with regard to the evidence, but with regard to the bind over, Judge, the same argument that Ms. Watt made with regard to the felony firearm charge applies even more to my client. There was no, let me just call it my client's case, and we'll separate out from the other two. There was no evidence in my client's case with regard to firearms at all. Who carried, who didn't, what knowledge anybody had of firearms, etc. So if there has to be some knowledge and some aiding and abetting in a firearm case, there's no evidence, none, in my client's case with regard to that. So he should not be bound over on the felony firearm charges. And very briefly, again, Your Honor, with regard to the first-degree murder, I heard the argument that Ms. Shackelford made. The testimony at best for the people, puts my client at the scene. Doesn't put him inside, doesn't show any knowledge of weapons, doesn't show any knowledge of any intent to murder anybody. In order to aid and abet, you have to do something. You have to know, and more than know, you have to aid, abet, counsel, support, etc. So I understand the argument with regard to the felony murder, and I'm just going to leave that sit. But with regard to the first-degree murder, there's absolutely nothing to suggest that my client was the shooter or an aider and abetter.
Anything else, Ms. Watt?
I have nothing.
Ms. Shackelford?
No, Your Honor.
The court's listened to all of the testimony and makes the following findings: that the court believes that there is probable cause to believe that there is a phone ending in 8723 that is associated with defendant Moore, and that there is also probable cause to believe that there was a phone ending in 4931 that is associated with Mr. Groom, by the fact that there's probable cause to believe that on June the 7th, 2017, that Mr. Groom accompanied Mr. Richardson to the Toledo courthouse, where there's probable cause to believe that Mr. Groom left the jailhouse when Mr. Richardson was incarcerated and left with his blue truck and with his phone number ending in 4931, and that after leaving with that, there's probable cause to believe that between the date of June the 7th and June the 22nd, that there's circumstantial evidence and probable cause to believe that Mr. Groom had that phone. There's probable cause to believe that he had contact with his now deceased wife, who was located at the address of 401 Bancroft, and that had data indicated that was the phone number that was called the most frequently. There's probable cause to believe that Mr. Groom had that phone throughout that period. There's probable cause on the 8723 number that was testified to by the parole agent and verified through the Facebook account, that between June and August of 2017 that Mr. Moore had the other phone. There's also probable cause to believe that on or about the date of the murder on June the 22nd, that both defendants and the phones that they are associated with were at the 671 door address of Nicole Dillard, and that there's probable cause to believe that Mr. Moore was doing tattoo artist work, which further there's probable cause to believe that one of the people that he performed tattoos on that date and at that location were Mr. Groom. There's probable cause to believe through the cellular analysis as testified to by Special Agent Gavin, that those phones associated with defendant Moore and defendant Groom left the address of the 471 the 671 door address, and that those phones associated with those defendants by phone location and Google location on the evening of June the 22nd, 2017 at approximately 10:30 traveled up I-75 to I-275, exited off of South Huron Road to Judd, to the address as previously testified and associated with defendant Evans and his father Cecil, and that those phones associated with those two defendants then were identified coming up Sumter Road and turning into the Citgo gas station, with the testimony of Officer Street of I believe that the Dodge Ram and the Chrysler 300 as testified to, even in the confession testimony of Mr. Evans, that he was in the Chrysler 300, excluding using that testimony against Mr. Moore and or Mr. Groom, that vehicle pulled in to the Citgo gas station at approximately 11:43 p.m. on that night, did a 3-point turn, and then there were Google hits, GPS hits on both phones using a radius off of the road of Hull Road and encompassing victim Egypt Covington's house, and that after a period of approximately 5 minutes that those two phones, along with a phone identified as the victim's phone, left that location and went back Sumter Road to the location previously identified as the Evans home. And so I believe that all of this probable cause is an issue of fact for a jury to make a decision on whether or not this crime was committed by these defendants. But for purposes of probable cause for today, I believe that there's sufficient evidence for probable cause that a crime was committed and probable cause to believe that these defendants were involved in the commission of that crime. Now, as to the specific bindovers, I am going to bind over Mr. Moore on, except for the count 4 that was dismissed by the prosecution, on the remaining 7 counts. On the remaining 7 counts, actually, as listed in the complaint charged as to defendant Groom. And I will make a further finding that for the homicide first degree, for the premeditation, that I believe that there's probable cause that the prosecution's argument that the pillow was taken and placed over the victim's face before there was a gunshot to that pillow indeed rises to the level of a premeditation, that movement of and that action of the pillow gives it cause and pause to allow for probable cause that the murder was premeditated. And I'm going to bind over on that count. I'm also going to add for defendant Groom that count of homicide first degree and the request for the 3 felony firearm counts for the first degree murder, for the felony murder, and for the home invasion. As to defendant Evans, with his own testimony, I believe that it's probable cause in an issue of fact for a jury on the 2 counts for the felony murder and the home invasion. I'm going to bind all 3 defendants over as indicated on the record.
Thank you, Your Honor.
So at this point, I'm going to go off the record.
When's the AOI? 1 week?
That's what I just turned around to ask.
I'm assuming it's 1 week from today.